The death of Supreme Court Justice Antonin Scalia has created controversy in Washington over who should nominate his replacement. Joining us right now to go in depth is Michael Morley, professor at Barry University School of Law in Orlando. We appreciate you being here, Michael. Thanks for being here.
Thanks for having me.
Let's talk about where do we go from here. The Republicans want the next president to nominate. The Democrats want President Obama. What does the Constitution say should happen next?
This isn't a conflict that the Constitution gives a clear answer to. It's a real political fight. On the one hand, the president clearly has the constitutional prerogative to nominate a successor.
Okay.
But on the other hand, the Senate has the constitutional prerogative to give advice and consent. And so ultimately, if the Senate refuses to confirm the president's nominee, there's nothing he can do. So it becomes a clash of political wills, whether the president can amp up the political pressure on the Senate to confirm a nominee that he puts up, or if instead the Senate can hold out and allow the people to have a voice in the process by waiting till after the November elections.
Well, let's touch on that a little more. Republicans in the Senate are talking about delaying a vote on President Obama's nominee until after the next president takes office. Is there a precedent for that?
Well, there's certainly historical precedents for Supreme Court vacancies being kept open for a year or even longer. The most recent precedent would be when Abe Fortas resigned in May 1969. His replacement, Harry Blackmun, wasn't confirmed until over a year later.
Okay.
So the Senate certainly takes its prerogative to give advice and consent very seriously, and that has resulted in even substantial delays.
Now, there has been some debate among politicians regarding Supreme Court vacancies in past election years. What about lame duck presidents? How would this apply, and also in past cases regarding lame duck presidents?
Well, again, the fact that President Obama isn't eligible to run again doesn't in any way reduce his constitutional power to nominate a successor to Justice Scalia. It really becomes more of a political question. Should a president who is on his way out be able to nominate someone who can serve for the next 20, 30, even more years? What the Senate Republicans are arguing is it's more democratic. It's giving the people a bigger role to allow the new president, who will be serving 4 or even 8 years, to be able to fill the vacancy.
Do you think that either side, Republican or Democrat, has any right to fight each other in court if it comes down to that?
No, it's not really a judicial battle. It truly is a political contest. It's a clash of the president's constitutional power versus the Senate's constitutional prerogatives. And ultimately, it's not the sort of issue that a court would resolve. It's one that will ultimately be resolved in the court of public opinion and as a matter of political pressure.
How quickly could we see some turnaround? As you kind of touched on that earlier. Could it be something as soon as in the next few days? Could it be a year from now, which you mentioned has happened in the past? What are we thinking in 2016? It is an election year.
Well, I would imagine that the president certainly has a short list of people who, for whom at least some preliminary vetting would be done. I would imagine that the president would take certainly at least a few days before nominating someone. At that point, then, the ball is in the Senate's court. How quickly it's going to schedule hearings, how in-depth the hearings are going to be, if it's going to choose to delay those hearings. And so once the nomination is made, there's really very little the president can do to try to force the Senate to proceed if the Republicans are able to hold together and decide to wait till after the election.
Last question. How could this impact the election of 2016 with any of the candidates, whether they be Republican, Democrat? What kind of effect could this have?
Well, as of right now, the court has 8 justices who most people would say are 4 left-leaning, 4 right-leaning. And so if there is a dispute regarding the presidential election, if the court winds up voting 4-4, then whatever the lower court did, whether the case came up from a state Supreme Court or from an intermediate appellate court, whatever that lower court did would wind up being the binding ruling. That whatever opinion the Supreme Court comes out with, if it's tied, doesn't wind up having any legal effect.
Okay, so definitely it can weigh in, especially being 2016 and being an election year.